master your master calendar hearing, your first immigration court appearances. How do you master those? In this video, I'll talk about how to master your master calendar hearing. Bijoux.ngwanda here, immigration lawyer in the DC metropolitan area. If you're new to my channel, please go ahead and subscribe. If you're not new, welcome back. Thank you for subscribing, and please don't forget to hit the notification bell so you don't miss any of my videos. If you enjoy the content, please go ahead and share, like, and don't forget to comment below. We're talking about comments, not questions. If you need a consultation from me, please don't forget to call my office 202-751-2180. Email on display. Consultation fees apply as usual. Okay, how do you master that? So first of all, when you receive the notice to appear, okay, NTA, notice to appear in immigration court, most of the time the case gets referred to the immigration court because of basically either it's an overstay of visa or a benefit has been denied at the US CIS office. Then it gets referred to an immigration court, or the person has been found either deportable or removable on other grounds, maybe criminal grounds or anything else, inadmissibility grounds as well, right? And the person received the notice to appear. First thing first, you look at the notice to appear. You have to make sure that the notice to appear is not defective. How do you know that? The notice must contain the time, the place, and the date of the hearing. If you don't have those three elements, time, place, date of the hearing, okay? If you don't have those three elements, it means that the notice to appear is defective, okay? And when the notice to appear is defective, remember that in Garland v. I believe in Gomez v. Garland, that's where they wanted to pretty much allow some other people to apply for cancellation of removal, because back in the days, they will send two notices, okay? One will have a time and then one will have the date and the place. So they should have sent the notice with all those three elements at the same time. And that's why those some individual were able to apply for cancellation of removal under Gomez v. Garland, right? Three things: time, place, and date of the court appearance. If you lack those three elements, it means that the notice is defective. Okay, so we move on to the next thing. The next thing, I believe the last one, is that you look at on your charging document, the removability grounds. What exactly are they talking about? Usually they will talk about something like, well, you have overstayed the visa, you are not a citizen of the United States, you have been found removable or deportable under section so and so, right? You have to really look at that charging document, because sometimes the facts are not correct, and you have to basically try to correct those facts at your first master hearing, because otherwise you waive your right, because you're not going to come to the individual, the actual trial, and start correcting the fact that you should have done it when you went first at your master hearing. Let me give you a specific example. We have a case where they said that, the alien, right, the non-citizen, entered the United States on such and such a date, which was not the correct date, because remember, the person first entered the United States on a different date, and then they left because they went for a vacation of 1 week, and then they came back on a second date, which they didn't stay longer outside of the United States. So they have been continuously living in the United States for a period of 10 years, right? So that 1 week alone could have prevent that person from applying for cancellation of removal. So we had to see those facts for what they were, right? Sorry. And we tried to correct those facts at the first master calendar hearing. So you need to look at those charging documents and make sure that those facts are correct. Facts are facts, and they have to be correct. If they're not correct, that's why you are going to make sure that you address that. And sometimes you can have another thing that the fact not just is not correct, it's even misrepresented. You know what I mean? Like, we had a case where they put in the charging document that you are removable because you enter into a fraudulent marriage. But they put it like that, but the USCIS decision wasn't that. The USCIS decision was that the application was abandoned. That's why they got the person overstayed their visa. They had no ground or no right to stay on the American soil. They had to be removed. That's why they have the first court appearances, right? So, well, we had to correct that, because you can't just say fraud when the decision letter from the USCIS say otherwise. So we had to correct that at the master calendar hearing. That's the second thing, okay? And then the last thing is, what are your basically your reliefs? What are your defenses? What type of form of reliefs are you trying to seek? Because remember, you can still amend the pleading later on, but you have to know what you're trying to seek. Most of the time it's asylum, withholding of removal, or convention under torture, right? The other thing some people have as a defense is adjustment of status based on the fact that they got married, and then the one adjust status, or the child turned 21, the one adjust status. Some other people, they have this defense of basically a cancellation of removal, right? And really, you can have all sorts of defense, or some other people come to defend the same application that they apply at the USCIS. So sometimes they defend the same application, which is VAWA, which is green court marriage, because the judge at that point, they have the authority, or they have the jurisdiction over that case to pretty much decide on the same thing that was denied at the USCIS. So that's why you are actually before the judge. So don't be confused, or don't miss your chance to lay out your foundation on what is to be basically defending later on in the process, in the trial. So that's why you have to master your first master calendar hearing, okay? Master it so that you lay a good foundation, and when you come back for trial, you really have already laid your foundation, and you can just go ahead and defend your case. And sometimes too, it is really important to do it, because a lot of people even waive their right to really defend the things that they should defend. We have people who have lost their right to defend their case, basically waive their right because you don't say it, it's considered waive. You don't say it again on the individual hearing, it's considered waive. Well, you gotta lay your foundation right there at the master calendar hearing. This is it for today. It is Sunday. My friend, if you need a consultation, we are working with complex immigration cases. We do offer all type of services when it comes to immigration law. And again, we do offer services for family-based, pretty much matrimonial law in DC, for DC residents only, which is divorce, child custody, alimony, all those fights that related to family, negligence, and all that. So until next time, bye-bye.